In this presentation, we will examine the recent events surrounding Qantas Airways, which have caused severe reputational and financial harm to the corporation. We will then explore the underlying corporate governance failures centering around former CEO Alan Joyce's role, dominance over the board of directors, all key themes of corporate scandals. I will first present a brief outline of the important facts caused by a series of questionable decisions by the company and its CEO during the COVID-19 pandemic. Tehi and Abiram will then analyze Qantas' governance failings, its response, and propose some internal reforms. Lastly, Ron and Ben will evaluate the legal implications of the board's failure to prevent the CEO from causing long-term harm to the corporation's values. During the pandemic, many flights were cancelled, and the corporation gave consumers compensatory travel vouchers instead of refunds. But these vouchers' expiry dates were so short that they would have expired before the restrictions were lifted. As a result, Qantas faced a class action lawsuit and ended up removing the expiry dates in summer 2023. When flights began again, consumers noticed that the prices were much higher than before. They almost doubled since 2019. Also, in late 2020, Qantas fired 1,700 baggage handlers across 10 airports and outsourced these job positions without rehiring the fired workers. A federal court ruled that Qantas fired these people illegally, and in September 2023, the Supreme Court rejected an appeal. These events went public in summer 2023, and the public realized that all of these had happened while Qantas was making record profits, leading to generous bonuses to the CEO and other executives. They were also spending millions in buying back shares and boosting their prices, and throughout the pandemic, Qantas had also been receiving state support. Then, on the 29th of August 2023, the Australian Competition and Consumer Commission launched an action against Qantas because between May and July 2022, it had advertised and sold tickets for about 8,000 flights that it had already cancelled or planned to cancel for many days and waiting for other many days before notifying the cancellation. The proceedings ended with a fine of 100 million Australian dollars and 20 million Australian dollars in consumers' refunds. The public fallout after this announcement was immense and share prices fell. Alan Joyce retired from his position of CEO in September 2023, 2 months earlier than he had planned. However, the shareholders still questioned his conduct and the conduct of the board and the large payout to Joyce, going so far as to echo the chair at the annual general meeting in November 2023. Qantas then committed to an independent internal review, which published its report in August 2024. The report found that the board had been overly subservient to Alan Joyce, allowing controversial decisions. Qantas also committed to reduce Joyce's payout as well as those of the other executives. However, the findings of the report exposed clear governance failings that they and Abiram will now explore.
Next, we will analyze two governance failures at Qantas, which are CEO dominance and flawed executive compensation. First of all, the dominance of Alan Joyce is an interesting one. He was an established figure in the airline industry, well known for his decisiveness. Travel firms are more likely to appoint dominant CEOs than others. Indeed, Qantas had a terrible year in 2008 when Joyce joined. He took several controversial and unilateral decisions across his tenure. In 2011, he grounded Qantas' entire fleet and engaged in a loss-making flight with competitor Virgin Air in 2014. CEO dominance occurs when the board permits the CEO to exert too much power over corporate decision-making and abdicates the board's responsibility to rein in CEOs who behave contrary to the shareholders' corporations. Dominant leadership leads to groupthink, which leads to deference and a lack of questioning. This is precisely the situation that prevailed at Qantas. The problem with CEO dominance is that it is only ever questioned after harm has already been caused. Before harm became obvious at Qantas, the problems at Joyce's dominance were papered over by public-facing success since Qantas reported a short-term increase in profits. The dominant approach among financial economists is to view executive compensation as schemes designed by boards to give executives the right incentives to maximize shareholder value. A different approach, the managerial power, suggests that executives yield power over their own pay, upsetting the incentive mechanism. Simply put, The more outrage an arrangement is likely to generate among an external audience, the less likely the company will be to actually pass such an arrangement. Further, departing CEOs are given generous compensation even when they leave after dismal performance. All these factors contribute to suboptimal pay structures within companies. This is exactly what happened at Qantas. The power of Joyce to the board was very high, and he collected increasing compensation despite sharp dips in company performance. At the time of his exit, he was supposed to receive $21.4 million for his last years in charge. This exit payment was only limited after the outrage it caused among the company's shareholders. Therefore, the facts of Qantas' case align rather well with this theory of managerial power and executive pay.
Now, to say the least, the incentive structure and executive payments at Qantas was imperfect. Now, during 2021, 22, and 23, the majority of Joyce's pay package consisted of payments under a long term incentive plan. Now, these LTIPs are supposed to reward executive behavior that benefits the company in the long term. And the irony of Joyce receiving high LTIP payments during this period is apparent. The scholarship describes the separation of pay and incentives as a common consequence of managerial power, and it is clear that this is what has happened in Candace's case. Now, coming to proposals for reform. Now, from the perspective of CEO dominance, the recommendations of the internal report sort of consisted of vague commitments to better performance. But considering the depth of the problem, perhaps a more radical solution is in order. The new CEO is the former chief executive officer at Qantas and was part of Joyce's leadership group. Out of 8 total directors, 6 were appointed before Joyce's exit. Therefore, it is hard to be optimistic that former patterns of deference will not, under any circumstance, continue. Scholarship generally agrees that at the very least, the chair and the CEO should be different people. However, in Qantas, this is shown to have not worked in adequately restraining the CEO. Therefore, a stronger proposal for reform is to separate the CEO from the board of directors. This would allow for greater independent consultations, facilitate information flows that are not driven by the CEO, and embolden a board that was hitherto reluctant to express its voice, leading to an important cultural change in the way that the company operates. Now, with regard to remuneration, the report found that incentive structures in remuneration were heavily weighted towards financial performance. Now, while Qantas committed to changes in short term incentive structures, its response on the LTIP front was lacking. It merely committed to broader board discretion going forward without further elaboration. Now, achieving stakeholder expectations is a necessary condition for long term sustained value creation. We propose that Qantas actively solicit perspectives from different stakeholders and use this information to calibrate clear LTIP targets and incentives. Interestingly, the internal report did call for Qantas to improve communication across its stakeholders, but did not subsequently relate this to LTIP incentives. The LTIP targets must also be clearly outlined in the annual remuneration report, which must also explain precisely how the targets were arrived at in order to improve transparency and show shareholders that sustained targeting of stakeholder interests is vital to enhancing long term shareholder value while also justifying the pay that the executives are receiving. The long term incentives should flow logically from the short term incentive structures. Qantas has committed to including customer, employee, and reputation based metrics in short term incentive plan calculations. These should target the achievement of milestones that are required to achieve long term outcomes that form the basis for LTIP based incentive payment mechanisms.
Before any corporate law issues with Qantas are analysed, it is important to identify the key differences present in Australian corporation law and Delaware law. Director duties in Australia are found within the Corporation Act 2001, and director duties in the Delaware law are found within the Delaware General Corporation Law. Both directors in Delaware and Australian law owe a duty of care and loyalty. In both jurisdictions, these duties are owed to the corporation. Under Delaware law, the duty of care is only concerned with the director's decision making. Directors need to show they make a careful decision making process using all reasonably available information to make a fully informed decision. Article 102b7 is an exculpation clause that protects directors from any form of liability as a result of poor business decisions. Under Australian law, the duty of care is found under Section 180/1 of the Corporation Act, stating that directors must exercise their powers and discharge their duties with a degree of care and diligence. In contrast to Delaware law, this duty is not only limited to decision making. This degree of care is determined by an objective standard of care that a reasonable person would exercise if they held the same responsibilities as the director and experienced the same circumstances as the corporation. Directors may therefore be held personally liable for breach of the duty of care. Both jurisdictions have the business judgment rule. In Australia, the rule is codified in Section 108(2) of the Corporation Act, whilst in Delaware it is a common law principle. In both jurisdictions, there is need to rebut the presumption that directors act in respect to the duty of loyalty, such as making judgments in good faith, with no personal interest of directors involved, and in the best interest of the corporation. Both jurisdictions possess similar criteria for the director's duty of loyalty. In the Australian Corporation Act, the duty of loyalty is not explicitly mentioned, but can be inferred through Sections 181 and 182. Section 181 states that directors must exercise their powers in good faith for the best interest of the corporation and for a proper purpose. Good faith possesses very similar meaning in both jurisdictions, focusing upon the director's scienter for liability. A proper purpose in Section 181b is a fiduciary duty that requires directors to exercise their powers as properly intended in promoting the corporation's aims. Section 182 is dedicated to forming liability for a director's abuse of his own position of power. In Delaware law, the duty of oversight is found within the common law. In Australian law, in contrast, the duty of oversight is not explicitly stated, but derived from Section 180/1, which states that the director of a corporation must discharge their duties with a degree of care and diligence. Instead of a set of criteria for implementing a managing reporting system that is stated in Caremark under Delaware law, in Australian law, the objective reasonable test is used again to determine whether the director had breached his monitoring duties. Delaware uses a more flexible approach to interpretation because a high majority of its fiduciary duties principles stem from common law. Australia, in contrast, has a more rigid approach upon the statute's wording, resulting in a stricter requirement for a breach of fiduciary duties. It may be more challenging, therefore, to successfully ground a claim for a director's breach of fiduciary duties in Australian law than in Delaware law.
Okay, so as for non-compliance with Australian fiduciary duty, the director's failure to challenge a CEO, as we've seen in many instances, there's been times where the directors have failed to provide a checks and balances system with the CEO and just feed into the CEO dominance. And among the board of directors of Qantas, this failure is a breach of Section 180, which is basically that the directors are supposed to exercise their powers and discharge their duties with the necessary degree of care and diligence, and is in reasonable fashion. They're supposed to do it in reasonable fashion. And because the directors didn't take action to challenge the dominance of the CEO, they didn't uphold this idea of using their power within reason, which shows a breach in the clause. Also, a failure against the CEO dominance is a breach of Section 181A, which is basically that breaching the duty of loyalty and the fact that directors were not acting in the best interest of the company by allowing the powers of the CEO to go unchecked. More into this topic of CEO domination, the excessive executive compensation amid the financial struggles of the company is something to look into as well, as the CEO compensation packages were extremely high, despite the difficulties that the Qantas was going through. And this is a violation of Section 182, as the directors were improperly using their position for unacceptable interest of the unacceptable interest of appeasing the CEO's personal interest and self-advancement, which in turn puts the already financial struggling company in a worse position, which causes harm to the company, which is also another extension of the Section 182. This also falls back into the violation of best interest, but this time through Section 180, Part 2, Parts A and D, as making that business judgment. Directors could not have believed that the decision for excessive compensation was in the best interest of the corporation, especially at the time of grave financial difficulties. In terms of another way that they breached fiduciary duty is the misleading public by selling tickets for canceled flights. Qantas enforced a compliance mechanisms such as the Code of Conduct of Ethics and Mandatory Trading, which were designed to ensure compliance with competition and consumer laws, and this had all failed. As it demonstrates a failure of the board to have general oversight concerning the duties with passing down to lower management, and the sale of canceled flight tickets demonstrates a clear communication failure between the board and the management, and addresses the inadequacies in the existing mechanisms. And the duty of oversight derives from Section 180, as it's included in the actions of director, which are to be carried out in a reasonably and in good faith. The lack of oversight in this case with the management team is therefore a violation of their obligations to the corporation, thus a violation of the law. And the final breach is the unlawful outsourcing of workers in the aim to prevent employees engaging in their rights to industrial action, as it's a violation of sections 180 and 181, as the director's compliance and overseeing involvement in firing off these employees and rehiring shows that they didn't exercise their powers and make business decisions in good faith for a purpose which represents the best interests of the corporation.